So what I'd like to do now is introduce from our Palm Beach Gardens office, one of the very few as well, board certified specialists by the Florida Bar in condominium and plan development law. We don't have many of those in the state. We have one today for our HOA board member certification class, Ms. Danielle Brennan. Danielle, it's all yours.
Thank you very much, Jeff. Good afternoon, everyone. Thank you so much for joining us. As Jeff was saying, my name is Danielle Brennan. I am a board certified specialist in condominium and plan development law here in Kaye Rembaum's Palm Beach Gardens office. There are 21 attorneys in total for our firm in both in Palm Beach Gardens, the Pompano Beach office, which is our main office. We also have an office in Tampa. We will be opening an office in Orlando, and we have offices in Miami and Dade with by appointment only. I am one of 10 board certified attorneys at Kaye Rembaum, most of them being in condominium and plan development law. And we actually have one board certified attorney in construction law as well. Providing representation to community associations is our bread and butter. This is what we do day in, day out. And as the board certified specialists that we are experts in this area of law. Yes. As Jeff was saying earlier, there is a lot of information today that you will be receiving in the PowerPoint. If you don't have the PowerPoint already, you'll get it afterward. You don't need to take copious notes. And you will get access to all this information. I'm not going to go through every single slide. There's like 173 slides. We won't have the time to do that today, so I will skip around. And I want to make sure that you guys stay through the entire presentation, because at the end, we're going to get to everyone's favorite topic, which is assistance animals. So let's get going. I will share my screen here so you guys can see the PowerPoint. All right, and away we go. So why are you here? This is not an existential question. This has to do with your certification. Florida statutes requires that all board members be certified. There are two ways to be certified. You can submit a certificate of having satisfactorily completed this class right here that you're taking today, or you can certify in writing that you've read the governing documents, will work to uphold them and faithfully discharge your duties, what I call the Scout's honor. And the certification has to be done within 90 days after your election or appointment to the board. It can also be done a year in advance if you do the curriculum certification. With that little certificate piece of paper photograph that you're going to take at the end of this presentation of your certificate, you're going to hand that to your secretary or whomever holds the official records of the association. That certificate needs to be on the association's official records with the association's official records for 5 years. And that certification is good for an uninterrupted tenure on the board. So if you're on the board, you come off the board for a year, you get back on the board, you're gonna have to be recertified. A lot of times we get the question, well, how often do I need to do the certification if I have an uninterrupted term? Because you have the 5-year certificate requirement. We recommend that you take it every year, because we update the presentation every year with the updates to the legislation. So after July 1st of every year, there's typically going to be some new law that the Florida legislature has passed affecting condominium or homeowners associations that gets incorporated into our presentation, typically around the late September, early October time, because that's when the division provides its curriculum. A director who fails to timely file their written certificate isn't deemed off the board, but they're suspended from service, and the board can temporarily fill that vacancy during the period of suspension. As soon as they become certified, the suspension ends. Simply because the director has not provided the written certification or the educational certificate doesn't mean that any board action taken is invalid, but you need to get that done as soon as possible. So homeowners associations are governed by Chapter 720 of the Florida statutes. And you remember Jeff saying at the very beginning that this class is for homeowners associations, not condominium associations. While the two are very similar in many ways, they're also very different in many ways. Homeowners associations are creatures of the common law. There's no statute that needs to exist in order for homeowners associations to exist. That's very different from a condominium. They are creatures of statute. They only exist because the statute provides them with the ability to essentially create title out of air, and to create that legal description, which is based on the declaration of condominium, as opposed to in an HOA, where your legal description in your deed will likely say lot number of plat of Sunnyvale community, recorded in plat book number page of the official records of the county that you live. There are a lot of other administrative things that are very different between an association board, a homeowners association board, and a condominium association board. And that typically when it comes to alterations of the common area in a homeowners association, the board generally has purview over those types of things. Whereas in a condominium, when it comes to making changes to the common elements, the board typically cannot do any alterations without 75% approval of the unit owners. When we're looking at Chapter 720, it really gives statutory recognition to the corporations that operate residential communities, provide procedures, protect certain rights of the homeowners. However, these provisions don't apply to anything that's commercial or industrial or any other non-residential use, and to any association that might be a condominium association, which are governed by Chapter 718, a cooperative, which is 719, mobile homes, unless those provisions are expressly incorporated into Chapter 720, which we'll talk about later when we discuss election disputes and things like that. So we know that Chapter 720 governs homeowners associations throughout the state of Florida. But as I said before, it changes nearly every single year. So what version of Chapter 720 applies to your association? Well, we essentially have to fall back on Contract Law 101. All of the substantive law in effect at the time of contracting is essentially incorporated into the contract once it's executed. So whatever the law was at the time that the declaration was entered into will be the substantive law that's applicable to the declaration throughout its time. Now, there are, of course, exceptions to that rule. If you've ever heard the term Kaufman language, that's a term that's borrowed from condominium law, where the case was under the name Kaufman. And it's that special language as amended from time to time. So if your declaration includes reference to Chapter 720 of the Florida statutes as amended from time to time, your declaration will change substantively as the statute changes. So this is something that you're going to want to refer to your attorney to take a look at to see if you are in fact either subject to Chapter 720 when the declaration was recorded, or if you are subject to the different changes that have happened to Chapter 720 as time has gone on since the recording of the declaration. In the event the declaration does not have the Kaufman language, then we have to look at what type of legislation it is. Is it retroactive? Is it a matter of public policy? Because generally when changes to the statute are a matter of public policy, they're going to apply notwithstanding the absence of Kaufman language. Sometimes the legislation itself says that it is remedial in nature or is clarifying existing law. In those cases, it would apply to your governing documents, notwithstanding the absence of Kaufman language. As I was saying before, with Kaufman language, the substantive changes to the law apply. But that leaves off another grouping of laws called procedural laws. We have our substantive laws. Those describe the legal duties and rights. And once those duties and rights are vested, legislature cannot retroactively abolish or curtail those rights and duties. Whereas procedural laws are more of like the how-to. They provide the means and methods for the application and enforcement of existing duties and rights. There are some examples on here. A lot of them are borrowed from condominium law, configuration and size of a unit, ownership and share and common expenses and surplus, appurtenances to the unit, possibly the lot. And one that was provided by Miranda Holmes is about a cause of action. Once it accrues, it becomes vested and it's a protected vested right. So we know we have Chapter 720 specific to homeowners associations, but all of our homeowners associations within the state of Florida, I shouldn't say all, most of the associations, homeowners associations in the state of Florida are also not-for-profit corporations governed by Chapter 617 of the Florida statutes. 617 is very general, provides some of the procedural issues or requirements of not-for-profit corporations that are then either made more specific under Chapter 720. So what happens if there's a conflict between the provisions of 720 and 617? Well, 617 provides us some guidance. In that event, the specific provisions of 720 specific to homeowners associations are going to control over any of the provisions in Chapter 617, which is just your general not-for-profit corporation act. So in a homeowners association, we have a variety of governing documents. The main document being your declaration of covenants, your declaration of restrictions, easements, whatever it may be called. These are covenants that are recorded against your property that run with title to the land, right? This is going to be like your constitution. The Articles of Incorporation are really a corporate document that are specific to the formation of the corporation itself and the composition of the board, the composition of the membership, and may provide certain rights. The bylaws are the procedural how-tos. How do we hold a meeting? How do we cast a vote? How do we adopt our budget? Things like that would be set forth typically in your bylaws. Now that we have these different, and we also have rules and regulations, which are generally board adopted. When we're looking at these governing documents, what do we do if there's a conflict between the two or the three? If there's a conflict between the declaration, the articles, and bylaws, you have to remember the term a little dabble, do you? DAB. Declaration, articles, bylaws, the documents will take precedence in that order. Of course, like with most things, there is an exception to the rule. Sometimes Florida statutes will say, unless otherwise provided in the bylaws, unless otherwise provided in the Articles of Incorporation or the bylaws, this will apply. In that case, you would look to the articles or the bylaws, whatever the document that's referenced in the statute, to find the information that you need, even though there may be some contrary information in the declaration. A little bit about transfer fees and estoppel certificates. Transfer fees, as a matter of public policy, are disfavored because they may present an unreasonable restraint on alienation. However, there is an exception provided for any fee, charge, assessment, fine, other amount payable to a homeowners association that may be provided in the declaration. The most common of these being capital contribution or a fee associated with the processing of an application for a sale. Estoppel certificates of a few years ago, maybe, I don't know, time sometimes evades me, was put into the statutes, Florida statutes, in a brand new section 720-305851. Can't speak English today. Within 10 business days of receiving a written or electronic request for an estoppel certificate from an owner or mortgagee or either of their designees, the association has to complete and issue the estoppel certificate. It has to be completed by a board member, authorized agent, authorized representative of the association, which could include the manager or an employee of the association's management company. And it has to be signed by an officer or duly authorized agent of the association. On the same day that the estoppel certificate is completed and signed, it has to be issued to the requesting party, either by hand delivery, regular mail, or email. And it has to include the information in the form, in substantially the same form as provided by the statute. There are 3 categories of this information: general information, assessment information, and other information. General information includes date of issuance, who owns the property, what is the property, are there any parking spaces reflected in the books of the association for this property, if the account is in collection, what's the attorney's name and their contact information, what's the fee, and we'll talk about fees in a little bit, and the name of the requesting party. As far as assessment information goes, you need to know how much are the regular assessments, when are they due, what is the account paid through, what date is the account paid through, when's the next date of the installment due, how much is it, any assessments that might be owed on the property as of the date of the estoppel, and what may come due during the effective date of the estoppel. And it's very important to get that number correct. Some other information, whether or not there's a capital contribution fee, whether or not there's a transfer fee, if there are any violations on the lot, if the board is authorized to approve the transfer, and if they have approved the transfer, or if there's a right of first refusal, has the right of first refusal been exercised, and any contact information for other associations for which the owner is a member. That may be a master association, for example, and contact information for all insurance maintained by the association. As I said before, you have to put the fee of the estoppel certificate under that general information section, and the fees that can be charged are strictly regulated by the statute. If there's no delinquency on the account, you can only charge $150 unless they ask for it to be expedited within 3 days. Then you can add $100. Same thing with the delinquency. If there's a delinquency, you can charge the $250 and an extra $150. And if they ask for it expedited, you can add the additional $100 fee. In order to charge an estoppel fee, the authority to do so has to be established by a written resolution of the board or provided by a written management or maintenance contract. Typically, you would find it in a management contract with whatever management firm you guys are dealing with. If the association fails to deliver the estoppel certificate within 10 days of receipt of a request, you can't charge a fee for the preparation and delivery of the estoppel certificate. If the certificate is requested, but the closing doesn't occur, then no later than 30 days after that closing date, the person who paid the fee can request a refund of the fee, and the refund has to be made within 30 days after receipt of the request. Now, even though it's the association who is making the refund is actually the obligation of the owner. So the association can collect that fee from the owner. The right to reimbursement cannot be waived or modified by any contract or agreement. And there are prevailing party attorney's fees if legal action is required. Estoppel certificates delivered by hand or by email are effective for 30 days. If it's done by mail, it's 35. They kind of built in five days for mailing. If there's a need to provide an amended estoppel, say you found out additional information or a mistake was made, you can issue the amended estoppel. It restarts the clock, and you cannot charge a fee for an amended estoppel certificate. As I said before, the monies that are due to the association, it is very important to get that number right, because an association waives the right to collect any monies owed in excess of the amount specified in the estoppel certificate from any person who in good faith relies on the estoppel certificate from the person's successors and assigns. So very important to get that number correct, because you want to be able to collect everything that's owed to the association. Now, there is a way for the association to provide for purchasers, let's say, to get additional information regarding the association, and the association can charge a fee for that. It's $150 plus photocopying and any attorney's fees. Typically, this comes in the form of an prospective mortgagee asking for information regarding active litigation the association may be a party to prior to providing a loan. So now let's get into the mechanisms of the members' meetings. We have two general types of members' meetings: annual meetings, which, surprise, surprise, have to be held annually, and the election must be held at or in conjunction with the annual meeting as provided in the governing documents. And then we also have our special members meeting, which is essentially any membership meeting other than the annual meeting. It's held when called by the board of directors, or when at least 10% of the total voting interest of the association petition to have a special membership meeting. Again, your governing documents can provide a different percentage or different means of calling a special membership meeting. If the bylaws don't have a method for providing notice of membership meetings, the association must mail, deliver, or electronically transmit notice to all owners not less than 14 days prior to the meeting. In order to use the electronic transmission, you have to have written consent from the members to provide notice via electronic transmission. Evidence of having provided notice must be made by an affidavit executed by the person providing the notice, and that has to be kept on file with the association's official records. Notice has to be mailed or delivered to the address identified as the owner's mailing address in the official records of the association, or electronically transmitted if, again, the owner has consented in writing to receive notice by electronic transmission. All notices have to provide the date, time, and location of the meeting. And there is also the option for the association to conspicuously post or broadcast notice in addition to the mailing, delivery, or electronic transmission. When it comes to agendas or your order of business, annual members meetings, unless the governing documents require that an agenda be included on the notice, there's no need to, there's no requirement under the statute. However, you should consider doing so anyway so that people know what's happening at the meeting. For special members meetings, business conducted at special members meetings is limited to the purposes described in the notice. So you have to provide a description of the purposes for which the meeting is called. Owners have the right to attend all membership meetings and to speak at any meeting with reference to all items open for discussion and all items included on the agenda, notwithstanding any provision in the governing documents. To the contrary, an owner has the right to speak on any item for at least 3 minutes. The association may, and absolutely should, adopt written reasonable rules governing the frequency, duration, and other manner of owner statements. And the rules have to be consistent, meaning you can't adopt a rule providing for 2 minutes. For example, members' meetings must be held at a location accessible to physically handicapped persons if it's requested, unless a lower number is provided in the bylaws. Remember when we were talking about a little dab will do ya? This would be one of the exceptions to that rule because it's referring specifically to the bylaws. Unless a lower number is provided in the bylaws, 30% of the total voting interest of the association constitutes a quorum at a members' meeting. Unless otherwise required by law or the governing documents, decisions that require the vote of the members must be made by the concurrence of at least a majority of the voting interests present in person or by proxy at a meeting at which a quorum is obtained. We simply refer to this as a majority of a quorum approval. As we were talking about before, proxy attendance, proxy voting. A proxy is essentially a document that says that this person can attend the meeting for me and cast my vote for me. There has to be certain information provided in the proxy in order for it to be valid. It has to be dated, include the date, time, and place of the meeting, and be signed by the person who's authorized to execute the proxy, i.e. the person who has the ability to vote. A proxy is effective only for the specific meeting for which it's given and any lawful adjournments, and automatically expires 90 days from the date of the meeting for which it was originally given. They're revocable at any time by the person who executes it. You can provide for a substitution of proxy. Usually it's, at the very bottom where the proxy holder can say, this person will substitute for me. And a copy of an original proxy can be used if it's a complete reproduction of the entire proxy. So it's not necessary that you have the original in hand. There are two different types of proxies, general proxies and limited proxies. A general proxy essentially tells the proxy holder, here's my vote, cast it whichever way you think is best. A limited proxy says, here's my vote, cast it the way I tell you to cast it. This is one of the big differences between a condominium and a homeowners association. In a condominium context, you can only vote by limited proxy, but in an HOA context, that's not the case. And in fact, depending upon how your election is set up, proxies used in an election may have to be a general proxy, depending on the circumstances, of course. But both limited proxies and general proxies can be used to establish a quorum. Speaking of elections, your election has to be conducted in the manner set forth in the governing documents. There's no catch-all method of doing an election like in an HOA, like there is for a condo. A quorum of the members has to be established in order to conduct an election, and any other business that might be conducted at the annual meeting. Directors are elected by a plurality of the votes cast by the eligible voters, unless the governing documents provide otherwise. And typically your election procedures are found in the bylaws, although sometimes I have seen in articles, but typically it's in the bylaws. All members are eligible to serve on the board unless otherwise disqualified. A person who's delinquent in the payment of any monetary obligation to the association on the last day that they can nominate themselves, meaning if you allow nominations from the floor, it's as of the annual meeting date. If there is that delinquency on that last date, then they're not eligible to seek election to the board. A person who has been convicted of a felony is not eligible to serve on the board unless their civil rights have been restored for at least 5 years. And a person who has pending criminal charges for felony theft or an embezzlement offense involving the association's funds or property cannot be elected to the board. Unless the governing document or unless the bylaws provide otherwise, the directors serve a 1-year term. Nominations from the floor, that's a pretty typical HOA election procedure. If the election process set forth in the governing documents allows candidates to be nominated in advance of the meeting, the election is not required to allow nominations at the meeting. Sometimes governing documents do have that for an HOA, the pre-nomination procedure, but I find more often than not, nominations are typically permitted from the floor. An election is not required unless more candidates are nominated than vacancies exist. If an election is not required because there are equal number or fewer qualified candidates than vacancies, then you essentially will announce whomever has nominated themselves at the annual meeting, and they are automatically on the board by a process known as election by acclamation. Balloting, members have the right to vote in person, by proxy, unless otherwise provided in the governing documents, and in person. If the governing documents permit voting by absentee ballot, you're going to follow that 2-envelope system, very similar to a condominium, where you have a blank inner envelope with the ballot. You put that into an outer envelope with identifying information, the name of the owner of the lot, the signature of the owner, that gets sent into the association. Now, I think it's important to note that an absentee ballot is not the same thing as a secret ballot. A secret ballot's not the same thing, or I should say, a secret ballot is not the same thing as an absentee ballot. An absentee ballot will be secret because you're using the double envelope system, but it's not necessary that a secret ballot follow the conformity of an absentee ballot. All ballots and proxies are tabulated on the date of the annual meeting. Any challenge to the election process has to be commenced within 60 days after the election results are announced. And any election dispute between a member and an association has to be submitted to arbitration with the division. Now, that's the Division of Florida Condominiums, Timeshares, and Mobile Homes. Note, there's no reference in that title to homeowners associations. Well, the Division of Florida condominiums, timeshares, and mobile homes has jurisdiction for arbitration section has jurisdiction for two types of disputes: election challenges and recalls. So if there's an election dispute, that needs to get brought to the division. And this is one of those instances in which you would refer to the condominium statute for the procedures of how to do the arbitration. And we'll talk about recall toward the end of the presentation. Electronic voting. This is something that is occurring more and more with our associations, especially since more and more associations are opting to use electronic means for holding meetings. An association can use an online voting system for all owner votes, so long as the owner provides written consent to online voting, which is valid until the owner opts out. There are a number of requirements in order to establish online voting. One of them being that the board has to notice a meeting with 14 days notice sent by mail, delivery, or electronic transmission, and posted within the community to the membership. They hold their board meeting and adopt the resolution, and the resolution has to provide that the owners will receive notice of the opportunity to vote through an online system, establish reasonable procedures and deadlines for owners to provide their written consent, and for them to opt out of online voting. The system itself has to meet a certain criteria as provided by statute. The association has to provide each owner with a means to authenticate the owner's identity, communicate with the system at least 14 days before the meeting. The method used has to be consistent with the voting and election procedures provided in the bylaws. There has to be a receipt that's transmitted to the owner once they cast their vote online. And essentially, the vote itself has to be separate from the information, the personal identifying information of the member who voted. Generally, these things should be met by the online voting system or service that you use. And there are several out there these days. Generally, the officers are selected by the board immediately following the election of the directors at the organizational meeting of the board. The directors cannot vote by proxy or by secret ballot at board meetings. However, directors can use secret ballots in the election of their officers. There's no prohibition against changing officers midstream. And here there's a little bit of a trick question. Does the president vote? Well, if the president is also a member of the board, then technically, yes, the president votes, but they're voting as a board member, not as an officer. This leads us to the board of directors. Unless otherwise provided, the corporate powers of a corporation not for profit are exercised by the board. So it's the board that's responsible for carrying out the duties unless otherwise specified by law or the governing documents. Unless delegated, no one board member should be making decisions for the board, and the board is generally responsible for the maintenance of the association property and the health, safety, and welfare powers. Again, we talked about how the directors vote. Members of the board can use email as a means of communication, but they cannot cast votes via email. No board member, not even the president, should make unilateral decisions unless the power is delegated or unless it's an emergency. The officers and directors of an association have a fiduciary responsibility to the owners, and they have to act reasonably using their reasonable business judgment rule. It's okay not to be right on occasion, so long as that board is using their reasonable business judgment. With board meetings, all board meeting notices have to include the date, time, and place of the meeting. An assessment cannot be levied at a board meeting unless the notice of the meeting includes a statement that assessments will be considered and the nature of the assessments. This is not only applicable to special assessments, but also your general assessments, your maintenance assessments, by the adoption of the annual meeting or the annual budget. The same meeting requirements apply to meetings of any committee when a formal decision will be made regarding the expenditure of association funds, and to any meeting having the power to approve or disapprove architectural decisions with respect to a member's parcel. So all of your architectural control committee, ACC, ARC, whatever your acronym is, those committee meetings would be subject to the same board meeting notice requirements. Unless the bylaws provide otherwise, notice of all board meetings have to be conspicuously posted in the community at least 48 hours in advance of the meeting, except in the event of an emergency. And unless the bylaws provide otherwise, written notice of any meeting at which special assessments or an amendment to a rule regarding parcel use would be considered must be mailed, delivered, or electronically transmitted to all owners and conspicuously posted on the community property not less than 14 days prior to the meeting. In addition to any other authorized means of providing notice of the board meetings, the association can adopt by rule procedure for conspicuously posting the notice on the association's website, or if they have an application that can be downloaded onto a mobile device. It would have to be provided for the same minimum period of which the notice for the regular board meeting would be either that 48 hours or the 14 days. And is also required to have that physical posting or mailing, what have you. Any rule adopted has to include a requirement that the association send electronic notice to members whose email addresses are included in the association's official records in the same manner as required for the notice of a meeting of the members. And the notice has to include a hyperlink to the website or the app on which the notice is posted. I have yet to see an association that actually has an application. I'd be curious to know what that looks like. Compensation: a director, officer, or committee may not directly receive any salary or compensation from the association for the performance of duties as an officer, director, or committee member, except for participation in a financial benefit accruing to all or significant number of the members, reimbursement for out-of-pocket expenses incurred on behalf of the association, recovery of insurance proceeds from a policy of insurance, any fee or compensation authorized in the governing documents by a vote of a majority of the voting interests of the members present in person or by proxy. Again, that's that majority of a quorum vote. And a developer, or if the developer or representative, or if the director is a developer or is a representative serving as a director or officer of committee or committee member of the association, they're receiving their compensation as an employee of the developer and not as a director, officer, or committee member. The same conflict of interest provisions that are set forth in 617 would apply to contracts between the association and a director. If the association enters into a contract or other transaction with one of its directors or a corporation or entity in which the director is also a director or officer or is financially interested, excluding an affiliated homeowners association, then the board has to comply with the following requirements. Again, this is from 617. The proposed contract with the director must be fully disclosed to the board and the disclosure entered into the minutes. And then it must be voted and approved by 2/3 of the directors present. The contract or transaction has to be reasonable and fair to the association. And at the next regular or special members meeting, the existence of the contract with the director must be disclosed. And the contract can be canceled by a majority vote of the members present at the meeting. If it's canceled, the association is only responsible for the value of goods and services provided up to the time of cancellation, and it's not liable for any termination fee, liquidated damages, or whatever penalty for cancellation might be in that contract. Guilty until proven innocent. A director or officer charged by information or indictment with a felony, theft, or embezzlement offense involving the association funds or property is removed from office. The vacancy is then filled by the board until the end of the suspension period or end of the term, whichever occurs first. If the charges are resolved without a finding of guilt or acceptance of a plea of guilty or nolo contendere, that means no contest, the director or officer must be reinstated for the remainder of the term. And if they have pending charges, they cannot be appointed or elected to a position as an officer or director. And that's referring back to what we discussed earlier. So this is the $25 rule here, the excessive gift. On behalf of themselves or their immediate family, an officer, director, or manager cannot solicit or offer to accept or accept any good or service or value for which consideration has not been given by the person or by the person proposing to provide goods or services to the association. However, The officer, director, manager can accept food to be consumed at a business meeting with a value of $25 per individual, or a service or good received in connection with trade fairs or education programs. So if you go and see Kaye Rembaum at a trade show, you can take the goodies without the fear of being off the board for having exceeded this excessive gift rule. If the board finds that an officer or director has violated this subsection, the board must immediately remove the officer or director from office, and the vacancy is then filled in accordance with law until the end of the director term of office. Vacancies created by the board by the expiration of a director's term are filled by an election, which again has to happen at the annual meeting of the membership. If a vacancy occurs on the board before the expiration of a term, other than those created by recall, again, recall we'll talk about later, unless the bylaws provide otherwise, it may be filled by a majority of the remaining directors, even if the remaining directors constitute less than a quorum of the members or of the directors, or by the sole remaining director, or the board may hold an election in the manner provided in the bylaws to fill the vacancy. A vacancy filled by the board is filled for the remaining unexpired term of the seat being filled unless otherwise provided in the bylaws. All meetings of the board have to be open to all members except for meetings between the board and its attorney with respect to proposed or pending litigation where the contents of the discussion would otherwise be governed by the attorney-client privilege, and meetings held for the purpose of discussing personnel matters. Members have the right to attend all board meetings other than those exempted that we just talked about by law, and the right to speak at any board meeting with reference to all designated items. The association may, and again should, adopt reasonable written rules governing the frequency, duration, and other manner of member statements, including, for example, a sign-up sheet for members who wish to speak. Unlike the members' right to speak at membership meetings, there is no statutorily provided amount of time that a member can speak at board meetings. However, 3 minutes may be a reasonable rule. An owner may tape record or videotape both board and members' meetings, and the board can adopt reasonable rules regarding the videotape and video recording, like having to set up the equipment before and not moving the equipment around during the meeting, what have you. Board meetings have to be held at a location accessible to physically handicapped persons if it's requested by that physically handicapped person who has a right to attend the meeting, similar to a membership meeting. Chapter 617, coming back to our Not-for-Profit Corporation Act. Unless the articles or bylaws provide otherwise, the board is entitled to create 2 types of committees: board committees and advisory committees. Board committees are a majority of the people in the committee have to be directors unless the committee is created by the board or is otherwise authorized by the articles. And the committee relates to the election, nomination, qualification, or credentials of directors, or is involved in the process of electing directors. Advisory committees, on the other hand, are just that. They're merely advisory. They're not a committee of the board. They may not act on behalf of or exercise the powers or the authority of the board or bind the association to any action, but can make recommendations to the board, the officers, or to the members. Exceptions to the statute are made for certain types of committees, including the Finding and Use Right Committee. We will talk about finding and use right suspension soon. Architectural committees, which we touched on, we will touch on again, and organizing committees established under 72405 Florida statute. That has to do with covenant revitalization. We will briefly discuss the Marketable Record Title Act, which that is with reference to a little bit. A meeting of the board, is it? I don't know. When does a meeting of the board members become a board meeting? We often get asked this question, and reasonable minds will differ. Generally speaking, if the board members are getting together at dinner and not discussing anything concerning the association, that's not going to be a board meeting, notwithstanding that the quorum of the board is together. If the board members are together and they're talking and all of a sudden they decide, you know what, we should go with such and such pool vendor. Well, that is a board meeting. That really is a decision that needs to be made at a noticed meeting at which all members are able to attend. So if you're conducting business of the association, needs to be conducted at a properly noticed board meeting. Now that we've been elected to the board, we realize, oh my gosh, we've got all these responsibilities and we're not getting paid. We can't even eat a meal over $25. How do we get off this board? Well, there are 6 ways. 1, you can be recalled. Failure to satisfy the certification requirement. Again, that's not you're off the board, but you're temporarily suspended from the board until you become certified. Criminal charge of felony theft or embezzlement offenses involving the association funds or property, receipt of the excessive gift. You can resign in writing, or you can become more than 90 days delinquent in the payment of any monetary obligation due to the association. Now, this section is really just like a conglomeration of things that don't warrant their own section, but are notable to mention to you guys. Minutes. You have to keep minutes of all your membership and board meetings, even the ones that are closed. All meetings have to have minutes. Minutes do not have to be verbatim records. You don't have to say Johnny said this, Sally said this. They can be just a general description of what was discussed. All minutes of the board and of the members must be maintained in written form or another form that can be converted into written form within a reasonable time. And a vote or abstention from voting on each matter voted upon for each director present at a board meeting has to be recorded in the minutes. Right of access to parcels. The governing documents may grant the association a right to access an individual parcel in an emergency or for purposes of undertaking an owner's maintenance obligations on the lot in the event the owner fails to properly maintain the lot, or maybe even to correct a violation that any other violation that may be existing on the lot, for example, like having done an architectural change without approval. Excuse me. Material alterations and improvements. This is another area where we kind of borrow from condominium law with regard to the definition of what is a material alteration. As applied to buildings, the term material alteration or addition means to palpably or perceptibly vary or change the form, shape, elements, or specifications of a building from its original design or plan or existing condition in such a manner as to appreciably affect or influence its function, use, or appearance. What? That basically can include anything. Chapter 720 does not require membership approval for material alterations or additions to the common areas of association property. However, you're going to want to look to your governing documents to see if there may be a membership approval required. Sometimes the membership approval may be triggered by a dollar figure, be it a stated dollar figure or a percentage of the annual budget. Something you're going to want to take a look at before you decide to redo the clubhouse, something like that. Amending the governing documents, unless otherwise provided in your governing documents, amendments to the governing documents require the affirmative vote of 2/3 of the voting interests of the association. Amendments to the articles of incorporation and bylaws which affect or impose a quorum or voting requirement greater than the general quorum or amendment vote requirement are not required to be approved by the greater quorum or voting requirement then in effect or proposed to be adopted when voting to lower the threshold. There is a certain formatting requirement for amendments. New text has to be underlined, deleted text strike out. If the doing the underlining and strikeout detracts from the meaning or makes it incredibly difficult to review the amendment, you can just provide the amendatory language without that formatting, so long as you include in the amendment that it's a substantial rewording and see governing documents for current text. Florida statutes addresses the process of amending and governing documents when mortgagee consent to an amendment is required. It applies only to mortgages recorded after July 1st, 2013. And it basically has a negative consent. If after 60 days you don't have a response, the lender is deemed to have provided its consent to the amendment. Developers cannot exercise their unilateral power of amendment if the amendment would alter the general plan of development. Excuse me, in the cases you see that have a lot to do with like golf memberships. Amending the governing documents. An amendment to a governing document is effective when it's recorded in the public records of the county in which the community is located. Within 30 days after recording an amendment to the governing documents, the association has to provide a copy of the amendment to the members. However, if a copy of the amendment is provided to the members prior to the vote and it's not changed, then the association can provide notice to the members that the proposed amendment was adopted and that a copy of the amendment is available upon written request to the association at no charge to the member. The notice can be electronically transmitted to those who have provided, again, the written consent to receive notice via electronic transmission, and must also provide the official record book and page number or instrument number of the recorded document. The failure to timely provide the notice of recording of the amendment does not affect the validity or the enforcement of the amendment, but you do still have to provide that notice or copy. Now, this is fairly new, this particular statute regarding amendments to the governing documents regulating or prohibiting leasing and lease agreements. Any governing document or amendment thereto enacted after July 1st, 2021 that prohibits or regulates rental agreements applies to an owner who acquires title to a parcel after the effective date of the governing document or amendment, or an owner who consents individually or through a representative to the governing document or amendment. This is very similar to what's provided in the condominium statute. However, there are certain exceptions that don't appear in the condominium context. An association may amend its governing documents to prohibit or regulate rental agreements for a term of less than 6 months, and can prohibit the rental of a parcel for more than 3 times in a calendar year. And these amendments will apply to all owners, notwithstanding who approved them or who obtains title after the fact. These rental amendment restrictions do not apply to associations with 15 or fewer owners. Under the rental amendment restrictions, a change of ownership does not occur when beneficial ownership of the parcel does not change, when an heir becomes the owner, when an owner conveys the parcel to affiliated entity, and there's a description of what an affiliated entity is defined to mean. Under the rental amendment restrictions, a change of ownership does occur when, with respect to an owner that is a business entity, every person that owned an interest in the real property at the time of the enactment of the amendment or rule conveys their interest in the real property to an unaffiliated entity. Rules and regulations, again, we were talking about the different types of governing documents. Rules and regulations really are, for the most part, board adopted pursuant to the authority that's provided in the declaration articles or bylaws. Commonly pertaining to the use of the common areas, recreational facilities, use of the lots. Some governing documents may require membership approval of board adopted rules before they become effective. So you need to take a look at what your governing documents say regarding the adoption of rules and regulations. There was a brief time when Florida statutes included rules and regulations within its definition of governing documents, which had the unintended effect of requiring amendments to rules and regulations to be recorded amongst the official records of the county when that was never required before, and most rules and regulations are never recorded in the first place. That was fixed last year, and now that's no longer a requirement. Written notice of any meeting at which the board will consider the adoption or amendment of any rule regarding parcel use, again, has to be mailed, delivered, or electronically transmitted to all owners and posted conspicuously on the community property at least 14 days prior to the meeting. All other rules only require that minimum 48-hour posting, conspicuous posting requirement for that board meeting. As we were talking about before concerning covenant revitalization and not being subject to the committee requirements under 617, that is referring to the Marketable Record Title Act. Now, the Marketable Record Title Act essentially says that covenants recorded against land begin to expire on a lot by lot basis 30 years after the initial recordation. So, and that's very simplified. When we're looking at the declaration of covenants and we see that it was recorded more than 30 years ago, our, alarms start to sound, thinking that this declaration could possibly have begun to expire on a lot by lot basis. So that association will need to undergo a revitalization versus a preservation. And this gives you a little brief introduction of what those things are. A preservation is an action taken by the board before the expiration of that 30-year mark. It can be done in a few different ways. Written notice, where you provide a statement of marketable record title. Summary notice, which is the easiest way to do it and the way that most associations do it at this point in time, or an amendment to the declaration, which references the recording information of the declaration. If you don't timely preserve, you're going to have to do a revitalization. This requires appointing the organizing committee, sending out the governing documents for majority approval, and then affidavit submission of the approval to the Department of Economic Opportunity, who then gets to review it and say yay or nay on the effort. And if they approve it, then you have to do a recording and then send out a notice. It's quite the ordeal. It's very costly, takes a lot of time. So be mindful of your 30-year mark. With regard to that mindfulness of the 30-year mark, there is a statute now in play that at the first board meeting following the annual meeting, which is not the organizational meeting, the board is required to consider the desirability of filing notices to preserve the covenants or restrictions from extinguishment under MARTA, and to authorize and direct the appropriate officer to file that notice. Service of process: if you live in a gated community has to allow the unannounced entry of a process server into the community, where the process server is attempting to serve process on a defendant or a witness who lives in the community or is known to be within the community. There are certain circumstances when a licensed community association manager is required. Community association management means any of these following practices, like controlling or dispersing funds of the association, coordinating maintenance for the residential development, day-to-day services regarding the operation of the community, requiring substantial specialized knowledge, judgment, and managerial skill. When it's done for remuneration, and when the association or association served contain more than 10 units or have an annual budget in excess of $100,000. A person who performs clerical or ministerial functions under the direct supervision of a licensed manager does not themselves have to have their own license. There are certain professional practice standards applicable to managers. They have to discharge their duties loyally, skillfully, diligently, dealing honestly and fairly in good faith, with care and full disclosure to the community association, accounting for all funds and not charging unreasonable or excessive fees. The contract with the management firm or the manager can provide for the association's indemnification of the manager or the firm for ordinary negligence resulting from the manager's or the firm's act or omissions that is the result of an instruction or direction of the association, and any other negotiated indemnity or harmless provision. However, the indemnification cannot cover any act or omission that violates criminal law, derives an improper personal benefit, either directly or indirectly, is grossly negligent, is reckless, is in bad faith, is with malicious purpose, or is in a manner exhibiting wanton or willful disregard of human rights, safety, or property. Construction defect warranties. Essentially what this slide is saying is there is a warranty for improvements that serve the property, like implied warranties of fitness and merchantability to those essential services like the drains and the roads, things like that. Off-site improvements. Emergency powers. So this was recently updated for COVID type situations. Under this particular statute, the HOA can perform several actions in the event of a state of emergency. excuse me, unless specifically prohibited by the association's recorded governing documents. The board can designate assistant officers who are not directors, which will step into the shoes of an officer in the event the officer is incapacitated or unavailable. They can conduct, cancel, or reschedule association meetings, providing notice of meetings as practicable of a manner as possible. Meetings can be conducted in whole or in part by telephone, real-time video conferencing, or similar real-time electronic or video communication. And notice of decisions can also be communicated electronically. The board can mitigate further damages, meaning removal of debris and removal of wet drywall, whatever it is, drying out the property. In addition to the implementation of disaster plans, emergency plans can now be implemented before, during, or following the event for which the state of emergency is declared. And there are several other powers that can be exercised in the event of a state of emergency. Let's see. Okay, so notwithstanding that the board can prohibit access to certain portions of the property, the association cannot prohibit owners, tenants, guests, agents, or invitees of an owner from accessing the common areas and facilities for the purpose of ingress to and egress from the parcel when necessary in connection with the sale, lease, or transfer of a parcel, or the habitability of the parcel for the health and safety of such person, unless a governmental order or determination or a public health directive from the CDC has been issued prohibiting such access to the parcel. Any access is subject to reasonable restrictions adopted by the association. Now, these emergency powers are only in existence long enough that is reasonably necessary to mitigate further damage and to make repairs to protect the health, safety, and welfare of the association and its residents. The board can, without a vote of the membership, levy special assessments and borrow money using the association's assets as collateral to fund the repairs and to carry out the association's business. Driver's licenses, again, this is really if you have a gated community. It's unlawful for private entities to swipe the driver's license unless they have the consent of the individual whose license is being swiped, except when required for paying goods or services with a method other than cash to verify their age when buying age-restricted services, goods or services, and to prevent fraud or other criminal activity in certain financial transactions. You can swipe if the person provides their consent, and the association is not going to be prohibited from taking the information down manually. Budget, special assessments, and reserves. Let me just check my time here. Okay, once the board has prepared the proposed budget, it's typically adopted by the board. The governing documents must be reviewed for any specific notice requirements, or maybe there's even like a membership approval requirement, which I have seen, although very rare. An assessment, again, the meeting notice at which an assessment is to be considered has to provide that the assessment will be considered and the nature of the assessment. This isn't only for special assessments. This is also for your general assessments, your maintenance assessments that are levied upon the adoption of that annual budget. If the documents are silent as far as providing notice of that meeting at which the board adopts the budget is to be approved by the board, properly noticed meeting, which means 48 hours posting, conspicuous posting on the community property. Remember though, if it's a non-emergency special assessment, it's that 14-day notice sent to the members and posted. Before budget adoption, okay, unless the documents require the board to provide a copy of the proposed budget, there's no requirement under law to do so. However, you may consider sending it to the members. After adoption, the association must provide each member with a copy of the budget or a written notice providing that a copy of the budget is available at no charge to the owner upon their request. If requested, you have to provide it within 10 business days after receive the request. And that's similar to providing access to inspect and copy the official records. It's the same 10 business day requirement. Each year, the association has to prepare a budget that sets forth the proposed expenditures of funds or the maintenance management and operation of the community. And the association, it's adopted for a 12-month period, has to reflect the estimated revenues and expenses, as well as the estimated surplus or deficit from the end of the current year. Use last year's actual expenses to plan for next year's budget. Monies in the operating section of the budget are not restricted to any particular purpose, and therefore the association's board can use money allocated for one particular operating item for another. Just because you have cost overruns in one doesn't necessarily mean that you can't use money from another line item that you have monies left over from to compensate for that. There are two main sections of every budget, operating and reserves. If you have reserves, and by reserves, I'm more referring to what we can call statutory reserves. The budget for the association has to state the estimated common operating expenses on an annual basis, disclose the beginning and ending dates of the budget period, show the total assessments to be paid by each parcel on a monthly basis, or if it's quarterly, on a quarterly basis. Disclose separately all fees or charges paid by the association for recreational amenities if they don't have their own. Include reserves for capital expenditures and deferred maintenance if they were initially established by the developer or by majority vote of the total voting interests. Now, those two ways of creating reserves are what I refer to as quote unquote statutory reserves. Reserves that are not created that way would not be subject to the statutory reserve requirements. Operating portion of the budget identifies the categories of income and expenses that relate to the day-to-day operation of the association, have to be listed by account and classification, and should project the total proposed annual expenditure for each item, typically including administration, management fees, maintenance, rent for recreational facilities if you don't have your own, taxes on association property, insurance, and professional fees. Reserves. Reserves for deferred maintenance and capital expenditures. Well, we mentioned that, but what does that mean? Deferred maintenance means any maintenance or repair that will be performed less frequently than yearly and will result in the maintaining of the useful life of that asset. Capital expenditure means any expenditure of funds for the purchase or replacement of an asset whose useful life is greater than 1 year, or repair to an asset that will extend the useful life of that asset for a period greater than 1 year. Some examples: pavement resurfacing, improvements or repairs to the common areas, sidewalk improvements. Now, statutory reserves can be created by the developer or by the vote of the members. While the developer is in control of the homeowners association, the developer may, but is not required to include reserves in the budget. If they include reserves in the budget, the developer can determine the amount of the reserves included. However, the developer is not obligated to contribute to the reserves during deficit funding. Deficit funding meaning the developer will pay the difference between the actual expenses incurred and what they're collecting from the members and assessments. That deficit is what they would be funding. The declaration articles or bylaws cannot obligate the developer, may not obligate the developer to create reserves. So there is the question now of, okay, if the developer creates reserves but isn't required to fund it, will the association be required to fund it? How does it get funded? There were some changes to the reserve statute in 720 that have raised this question that has yet to be answered. If reserves are membership created, they're approved by a majority of the total voting interest of the association, and they have to be added for that, whatever the component is, to the annual budget once they're created by the membership. Again, has to designate the components for the reserve item. The board must then include the reserve account in the budget for the next fiscal year following the year in which the membership vote was taken, and every year thereafter. The statutory reserve account has to be funded, maintained, or waived in the manner provided by statute. And as I mentioned before, reserves created any other way, they're not subject to the statutory funding or waiving or use requirements as statutory reserves are. In computing reserves, You take that item and you have an estimated useful life for that particular item and the estimated replacement cost or deferred maintenance expense for that item. And you basically spread out whatever that amount is over the useful life. The association can adjust reserve assessments annually to take into account any changes in estimated costs of or the useful life of a reserve item. Funding formulas for statutory reserves must be based on a separate analysis of each of the required assets or a pooled analysis of two or more of the required assets. Unless the association maintains a pooled account of reserves, the reserve schedule should include each reserve account for capital expenditures and deferred maintenance or replacement as a separate line item with the following minimum disclosures: estimated useful life, remaining useful life, replacement costs or deferred maintenance expense, an estimated fund balance as of the beginning of the period for which the budget will be in effect. Again, that's referring to statutory reserves. Changing use and pooling reserves. For those statutory reserves, the money that's collected can only be used for that statutory reserve item unless use for another purpose is approved in advance by a majority vote of the members at a meeting at which a quorum is present. Pooling reserves is a similar mechanism. The association can pool reserves upon the vote of a majority of a quorum of the members. And the reason why associations may want to pool reserves is because it generally makes the reserve requirement, the dollar figure every year, a little bit lower because it calculates when the money needs to be drawn from that particular account. Waiving and partially funding reserves. Again, this is for statutory reserves. After statutory reserves are created, they have to be fully funded unless a majority of the voting interests of the members present at a membership meeting vote to waive or partially fund the reserves. If the vote is taken and approved, it's only applicable for that budget year. Whether or not the membership gets the opportunity to vote on that waiving or reduction of reserves is left within the discretion of the board. It's not required by law that the waiver or reduction of reserves be presented to the membership. Reserve accounts established pursuant to statute can be terminated upon a majority vote of the total voting interests of the association. If terminated, then those reserve items have to be removed from the budget. A little bit more about special assessments. They are assessments levied against an owner other than regular assessments. Unless the bylaws provide otherwise, written notice of any meeting at which the board will consider and adopt a special assessment must be mailed, delivered, or electronically transmitted to the members and posted conspicuously on the community property at least 14 days before the meeting. The meeting has to include a statement that a special assessment will be considered and the nature of the assessment, and should identify the estimated costs of the assessment. Once the board has adopted the special assessment, the board should send a notice to the owners of the adopted assessment and allow a reasonable period of time for the members to make the payment of the assessment. A special assessment that has not been paid by an owner can be collected in the same manner permitted for any other assessment through the lien and foreclosure process. Okay, if a member vote required and cannot be obtained, what is the board to do? So this is saying that even though special assessments pursuant to, I shouldn't say pursuant to statute, but generally special assessments can be levied by the board. Sometimes governing documents may require membership approval, whether it be for every special assessment, for a special assessment of a certain amount, for the third special assessment levied in a fiscal year. Depends what your governing documents say. If your governing documents require membership approval to levy a special assessment, but you can't get that vote, what can you do? Well, in that case, you would be amending your budget. Financial reporting. Each year, the board has to prepare and complete or contract with a third party, more like, for the preparation and completion of a financial report regarding the financial activities of the association for the preceding fiscal year within 90 days after the end of that fiscal year, or look at your bylaws and see what they say about when you need to provide your financial report. Within 21 days after the financial report is completed, but no later than 120 days after the end of the fiscal year, the board has to provide each member with a copy of the financial report or written notice that a copy of the financial report is available upon request at no charge to the member. There are certain types of financial reports that are required depending upon the annual reserves of the association. You may have to prepare a compiled financial statement if you're within that 150,000 to 300,000 bracket, or you may have to prepare full audited financial statements if you're of more than $500,000 in annual reserve. The level of reporting can be changed. If the board wants to raise the level of financial reporting, it can do so without membership approval, unless, of course, you check your governing documents if it requires otherwise. If the majority of a total voting interest approve raising the level of financial reporting, the board has to amend the budget or adopt a special assessment to pay for that, regardless of any provision to the contrary in the governing documents. If 20% of the owners petition the board to increase the level of financial reporting from that required by statute for that fiscal year, the board has to notice and hold a membership meeting within 30 days of the receipt of the petition. And the level of financial reporting may be reduced from the statutory level only if approved by a majority of the voting interests of the members present at a membership meeting. If the budget does not include reserve accounts created by the membership approval, or the declaration, articles, or bylaws do not obligate the developer to create reserves, and the association is responsible, for the maintenance of capital improvements, that may result in a special assessment if reserves are not provided for or not fully funded. Each financial report for the preceding fiscal year has to contain a statutorily provided statement warning of the consequence in conspicuous type. So if the budget does not provide for reserves or does not provide for fully funded statutory reserves, that first little paragraph there has to be inserted in the financial report. If the budget does not provide for statutory reserves but includes discretionary reserves, then you would be including that second paragraph there. Essentially says that we don't have reserves, or we have partially funded reserves because of this. If there is an instance in which maintenance or repairs are required, you're going to be subject to an assessment. There are some other governmental filings to be aware of. One is for the Division of Corporations. That's going to be your annual report. Usually, here it says January 1st and May 1st. Usually something that gets taken care of pretty quickly by management, and your annual income tax returns. A little bit about contracts and bids. Contracts have to be in writing if the contract cannot be fully performed within 1 year for the purchase or lease of materials and equipment, and if it's a service type contract. All written contracts entered into by the association for the operation, maintenance, or management of the association property serving owners should specify what are the obligations, how much is it going to cost, how often is it going to happen, and how many people are going to be on property doing whatever that service is. There are certain bidding requirements required by statute. If the aggregate cost of the contract is more than 10% of the total annual budget, which includes those reserves, the association must obtain competitive bids for materials, equipment, or services. The association is not required to accept the lowest bid, and the association is not required to obtain competitive bids for products and services in emergency circumstances, or if the products and services, or when the business entity in which the association desires to contract is the only source within the county serving the association. Contracts executed before October 1st, 2004, and any renewal of those contracts are not subject to competitive bid requirements. And these contracts are not accepted from the bid, or are exempt from the bidding requirements, do not have to be bid. Employees of the association contracts for the services of an attorney, accountant, architect, community association manager, engineer, and landscape architect. However, those contracts still have to be in writing because those are going to be service contracts. A contract with a manager, if made by a competitive bid, can be for a term of up to 3 years. If a contract was awarded under the competitive bid procedures, any renewal of that contract is not subject to such competitive bid requirements if the contract contains a provision that allows the association to cancel the contract on 30 days notice. An association whose declaration or bylaws provide for competitive bidding services may operate under those provisions in lieu of the statute if they're not less stringent than the statutory requirements. Less stringent meaning they have a 15% minimum requirement for bidding as opposed to maybe a 5%, which is 5% is actually for the condominiums in their statute. The association can enter into a contract for bulk communication, internet. They would be operating expenses of the association allocated on a per parcel basis, regardless of whatever the association's governing documents provide for as far as allocation is concerned. Any communication contract entered into before July 1st, 2011, in which the cost of the service is not equally divided among all parcel owners, can be changed to allocate them to equal costs by the approval of a majority of the voting interests present at a meeting. Any contract for communication, information, or internet services entered into by the board can be canceled by a majority of the voting interests present at the next regular or special meeting of the association, whatever occurs first. And any member may make a motion to cancel the contract, but if no motion is made or if the motion fails to obtain the required majority vote, the contract is deemed ratified for the term expressed in the contract. There are certain people for which exceptions are made for payment under the communication contract. Those who are hearing impaired or legally blind, and they don't live with someone who is non-hearing impaired or a sighted person. Parcel owner who receives supplemental security income under the Social Security Act, and those with food assistance as administered by the Department of Children and Family Services. They can discontinue services without incurring disconnect fees or penalties, and may not be required to pay any operating expenses associated with those services. Excuse me. If there is a communication contract, a bulk contract with the association, a resident of any parcel, whether a tenant or owner, may not be denied access to available franchise licensed or certified cable or video services if the resident pays the provider directly. So let's say our community has Comcast and I want Hotwire. I'm able to get Hotwire so long as I'm paying Hotwire directly. A resident or cable or video service provider may not be required to pay anything of value in order to obtain or provide such service, except for the charges normally paid for like services by residents of single-family homes located outside the community, but within the same franchise licensed or certified area, and except for installation charges agreed to between that resident and the service provider. As we mentioned before, let's go into fines and use right suspensions. Now, when we're talking about fines and suspensions, we're really grouping them into the type of violation. There is the grouping of those violations that are non-monetary and violations that are monetary. For everything but failing to pay monetary obligations, the association can fine and can impose use right suspensions. There is a process. First, the board has to levy the fine or use right suspension at a properly noticed board meeting. Once the board levies the fine or use right suspension, then you send out a written notice to the owner saying that the board has done the levy and that the owner has the opportunity to appear before the hearing committee, fining committee, whatever you want to call it, not sooner than 14 days. That has to be held not sooner than 14 days from the date of that notice. The hearing has to be before an impartial committee consisting of 3 members appointed by the board who are not officers, directors, or employees of the association, or the spouse, parent, child, brother, or sister of an officer, director, or employee. The role of this committee is limited to determining whether to confirm or reject the fine or use right suspension levied by the board. If they do not confirm the fine or suspension, it cannot be imposed. If they do anything other than confirm the fine, it's considered a rejection. Let's say the committee determines, oh, well, that $100 fine that the board levy be levied because you left your trash out past 6 p.m. the date after pickup. That's a little harsh. We think that a fine should be assessed, or levied, but not $100. Let's do $50. No, that's considered a rejection. A fine cannot exceed $100 per violation unless otherwise provided in the governing documents. And a fine can be levied on the basis of each day of a continuing violation, but cannot exceed $1,000 in the aggregate unless provided in the governing documents. A fine of $1,000 or more can become a lien against the parcel and collected through the lien foreclosure process if the authority to do so is provided in your declaration. And the fine payment is due 5 days after the date of the committee meeting at which the fine is approved. Now, moving to the other set of suspensions that can be imposed for monetary obligations. And this is for failure to pay monetary obligations greater than 90 days, not on the 90th day, on the 91st day, greater than 90 days. Through board action, the association can suspend an owner's right to use common area facilities if the owner is more than 90 days delinquent in any monetary obligation due to the association. Again, this is the board. Through board action, there would be no need for committee hearing. The motion can be done one time if done properly at a properly noticed board meeting. For the suspension to take effect, written notice of the suspension has to be mailed or hand delivered to the parcel owner, and if applicable, to the occupant, licensee, or invitee. This is applicable to, this particular slide is applicable for use right suspensions for both monetary violations and non-monetary violations. Even though the association can suspend the right of an owner or their occupant, tenant, what have you, from using portions of the common areas, the suspension does not apply to that portion of the common areas used to provide access to the parcel or utility services to the parcel, nor can it prohibit vehicular and pedestrian ingress to and egress from the parcel, including the right to park. The suspension will apply to the member, and when appropriate, the member's tenants, guests, and invitees, even if the delinquency or the failure that resulted in the suspension arose from less than all of the multiple lots owned by an owner, by a member. So if a member owns 10 lots and they were suspended for as a result of a delinquency on one lot, the suspension can apply for all lots. Voting suspensions. Now, voting suspensions are only applicable if there's a failure to pay a monetary obligation greater than 90 days. This is done again through board action, and the association the board would then hold a board meeting and levy the voting rights suspension at a properly noticed board meeting and send notice that the suspension has been levied. However, there's an important caveat here. In the condominium context, there was a case which essentially said that the declaration did not provide for the imposition of use right suspensions as a remedy for an assessment delinquency and did not include Kaufman language. Therefore, the association could not take advantage of voting right suspension under the statute. So you're gonna, before you decide to suspend voting rights, take it to your association's attorney, make sure that they review the governing documents to ensure that the association is well within its rights to suspend voting rights. Again, this is just talking about what I briefly just discussed: voting rights suspension for monetary obligations, failure to pay more than 90 days, done at a board meeting. You have to send written notice after the suspension is levied by the board, and it is applicable once the suspension is sent. You want to be careful with what you wish for, though, here. The suspension of voting rights will take away that particular vote from the calculation of what constitutes quorum and what's required to approve an action, but you could be taking away votes from the voting pool that would have otherwise approved whatever the initiative is. Covenant enforceability and dispute resolution. The association is charged with uniformly enforcing the governing documents. Uniformly because there is that defense of specific enforcement. So you want to make sure that you are, or selective enforcement, selective enforcement. You want to be sure that you are enforcing it evenly against everyone. There are some examples of what types of restrictions are commonly enforced. A community association through board action can extinguish a discriminatory restriction. And the association can institute, maintain, settle, or appeal actions or hearings in its name on behalf of all members concerning matters of common interest to the members, including common area, roof, structural components of a building, representations of a developer, protesting ad valorem taxes on common facilities, defending an eminent domain lawsuit. But there is this $100,000 rule. Before commencing litigation against any party in the name of the association involving amounts in controversy of in excess of $100,000, the association has to first obtain the affirmative approval of a majority of the voting interests at a meeting of a membership at which a quorum has been attained before they can initiate that litigation. Disputes between an association and an owner. There are certain disputes which have to go to pre-suit mediation before they can go to court. These disputes include use of or changes to the parcel or common areas, amendments to the association's governing documents, meetings of the board and committees, membership meetings, not including the election meeting, because remember election, that would be the division of Florida Condominiums, Timeshares, and Mobile Homes, access to the official records of the association, and covenant enforcement. Those disputes which are not subject to pre-suit mediation can go directly to court. And these typically have to do with money or landlord-tenant things, disputes, fiduciary duties. Those will all go straight to court. And again, recall and election disputes would go to the division. There is a statutory pre-suit mediation procedure. Before you can file a lawsuit, you have to provide the statutory offer to participate in pre-suit mediation. There is a form provided in the statute. You send the form to the aggrieved party, or the aggrieved party sends the form to the responding party with a list of 5 mediators, has to include a certain amount of detail regarding the mediators. Then the responding party is provided 20 days from the date of mailing that offer to respond with their selection of one of those 5 mediators, and the responses has to be sent by certified mail. An impasse in a mediation entitles the aggrieved party to go straight to court without further notice. An impasse occurs when a party fails to respond to the written offer within that 20-day period, fails to agree to at least one of the mediators that was suggested, or fails to make a payment of the mediator fee within the time established by the mediator, or fails to appear at the scheduled mediation. There are certain prevailing party attorney's fees that can attach in the event there's an impasse or what have you at the mediation and it goes to litigation. Architectural standards. So the authority of an association or any architectural construction improvement committee to review and approve plans and specifications for the location, size, type, or appearance of any improvement on a parcel, or to enforce the standards of external appearance of any improvement located on a parcel, is permitted only to the extent that the authority is specifically stated or reasonably inferred as to such location, size, type, or appearance in the declaration or other published guidelines and standards authorized by the declaration. If there are options for material, size of improvements, designs of improvements, the committee of the association cannot restrict the right of the parcel owner to select from those options provided in the declaration or other published guidelines. Essentially, if there is something, an improvement or alteration that the association wants to ensure it has the authority to govern, have a standard, have a guideline, adopt something to that effect, so long as the authority to do so is provided in your declaration. The failure of the association to enforce covenants, restrictions, and rules and regulations in a timely manner may result in the waiver or forfeiture of the enforcement rights. Typically, the first step in enforcement is to mail a letter to the owner, a friendly notice of the violation, saying this is what happened. This is a violation of this particular section of the governing documents. Provide a deadline for compliance, allowing that owner to correct the behavior, correct whatever the condition is on the property. If voluntary compliance is not achieved, maybe you send another letter, or maybe at that point you refer to the association's attorney. The attorney sends the letter before you go, to the pre-suit mediation option. And then once pre-suit mediation, if it is or is not successful, then the litigation option. Ultimately, treat people the way you want to be treated. Official records. This is referring to official records of the association, not official records that are recorded in the county. There are a number of documents and records that are included within the association's official records. Essentially, any written records of the association which are related to the operation of the association are official records of the association that have to be maintained. And the default is for 7 years. There are certain exceptions to that, like the director's written certification or education certificate, which is that 5 years we discussed at the very beginning. Bids for contracts, those bids have to be kept for 1 year. Ballots, sign-in sheets, voting proxies related to voting by owners have to be maintained for 1 year after the date of the election, vote, or meeting. And these new things called affirmative acknowledgements, those also have to be maintained among the official records, and we'll talk about what those acknowledgements are. There are certain documents which are not accessible to members, records protected by the attorney-client privilege or work product privilege, medical records of owners or residents, which becomes important when you're talking about assistance animals. Information obtained in connection with the approval of a lease, sale, or other transfer of a parcel, like if your association does background checks, credit checks, those would be inaccessible to members. Personnel records of the association, electronic security measures used for safeguarding data, and the association software and operating system, even if the owner has the same copy of the same software, Personal identifying information. So driver license, credit card, fax, telephone numbers, social security numbers, email addresses, emergency contact information, any address for an owner other than that provided for in notice requirements, and any other personal identifying information, excluding the name, parcel designation, mailing address, and property address, are not accessible to owners for inspection. Information that the association obtains in gated communities in connection with guest visits is also not accessible to members. And those affirmative acknowledgements, although they are part of the official records, are not accessible. Attorney-client privilege just provides you with a little discussion of what constitutes the attorney-client privilege. Just know that the communications between the board members and the attorney are typically covered by the attorney-client privilege, and that privilege is held by the board, not by the attorney. An association can print and distribute to owners a directory containing the name, personal address, and all telephone numbers of each owner. However, an owner can exclude their telephone number from the directory by requesting in writing that it not be included. The association is not liable for inadvertent disclosure of information included in an official record by the association if that information is voluntarily provided by an owner and not requested by the association. An owner can also provide their written consent to the disclosure of other information, which is otherwise not supposed to be disclosed by the association. The association has to maintain an adequate number of copies of the recorded governing documents to ensure their availability to members and to prospective members. The official records of the association have to be open for inspection and available for copying, including copying with a portable device, by members or their authorized agents at reasonable times within 45 miles of the community or within the county within 10 business days after receipt of written requests for access. If the records request is submitted by certified mail return receipt requested and the records are not produced, it creates a rebuttable presumption that the association willfully failed to disclose the records. The association can have a copy of the official records available for inspection or copying in the community, available electronically via the internet, and may allow the records to be viewed in electronic format on a computer screen and printed upon request. Cherry picking the records is not required. Yes, Jeff?
Just a quick question, and thought you might also use a little throat break for a second
Yeah,
too.
my voice always gets destroyed.
Now we know, most of us know that condominium associations that have 150 or more units in the association are required to have a website. HOAs are not required, correct? Okay.
Correct.
And I know you can't give a definitive answer to this, so folks, keep in mind this is not an answer, but have you heard any ramblings or anything in the background about potentially a law similar to that might be down the pike for a homeowners association? Have you heard
I
anything
have
to that
not.
effect?
I have
Okay.
not.
I was just curious because we get that question a lot, and
Yeah, I
a
mean,
couple of
and
people.
it makes sense. It's one of those things, like sometimes there are differences between the Condominium Act and the Homeowners Association Act that just don't make any sense. Like, why is there a difference between these two things? But
Yeah.
they exist, and that happens to be one of them. I don't know why. And
Yeah.
I don't know of any change coming down.
Okay, I was just curious because a website, even if a website is not required, it's such a great tool, and it can also help with frequently asked questions, reduce phone calls to the office, rumor killers. I mean, it's got
Yeah.
so many wonderful applications that even if it's not required, it's a good idea to have one. Just a
Yeah.
thought from
And
anyway.
I also think it's interesting that even though there is no website requirement, there is provision for having an app and posting notices on apps. Like homeowners associations are really that advanced in having an app. I haven't seen it yet. If you don't have a website requirement, why would any association have an app? But at any
Yeah.
rate, it's
I heard you
there.
mention app. I heard you mention app earlier. I haven't seen too many either. It is
Yeah.
really kind of a luxury because most of your websites today automatically conform to the size of a phone or a
Right.
tablet. That's called responsive. So, an app is just like an added convenience,
Yeah.
Anyway, back to you. Sorry for the interruption. Just a
No
thought.
worries. No worries. Thank you. So when the association is providing access to the official records for inspection and copying, there is no requirement that the association go through the official records and cherry pick the documents that are responsive to a request. The association may and should adopt reasonable rules governing the frequency, time, location, notice, records to be inspected, and manner of the inspection, but they cannot require a parcel owner to show any proper purpose for the inspection or state any reason for the inspection or limit an owner's right to inspect records to less than one 8-hour business day per month. The association can charge certain fees when it comes to providing copies of the official records, and these fees are governed by Florida statutes, 25 cents per page made on the association's photocopier. Obviously, you can't charge if the person brings their own scanning device, which I have seen members actually bringing in like a big scanner copier, putting it onto the table and making their own copies on their own copy machine. Or they can just take pictures with their iPhone, which often happens as well. There can be personnel costs if the time spent retrieving and copying the records exceeds half an hour, and if the personnel costs do not exceed $20 per hour. And additional information about copying records and the fees that can be charged there. The failure of the association to provide access to the association's official records within 10 business days after receipt of the written request by certified mail return receipt request, again, creates that rebuttable presumption that the association willfully failed to comply with the requirement. A member who is denied access to the official records is entitled to the actual damages or minimum damages for the association's willful failure to comply with this subsection. And those minimum damages are $50 per calendar day up to 10 days, with the calculation beginning on the 11th business day after receipt of that written request. So recall we were talking about those affirmative acknowledgements, how they are part of the official records but not accessible. And this is pursuant to a relatively new statute. If the association sends out an invoice for assessments or statement of account, they have to be delivered to the owner by first class US mail or by email. The statement of the account designates the name, the current address of the member who's obligated to pay assessments, the due date and the amount of each assessment charged against the member, and the date, the amount of each payment on the account and the balance due. Before changing that delivery method, the association has to mail written notice of the change to each owner at least 30 days before the association sends the invoice or statement by that new delivery method. The notice must be sent by first-class US mail to the owner at their address as reflected in the association's records, and if not the parcel address, then must be sent to the parcel address as well. If the owner then must affirmatively acknowledge electronically or in writing his or her understanding that the association will change its delivery method before the association can actually change the delivery method. The affirmative acknowledgement has to be maintained again among the association's official records, but is not subject to inspection and copying. In addition to that method of delivery and affirmative acknowledgement requirement, at the same time, the legislation included this notice of late assessment. The association cannot require payment of attorney's fees related to past due assessments without first delivering written notice of late assessment to the owner, which specifies the amount owed to the association and provides the owner 30 days to pay the amount owed without the assessment of attorney's fees. There is a form, it's set forth in this statute, has to be sent by US mail, first class US mail to the owner at their last address as reflected in the association's official records. And if that address is not the parcel, then also to the parcel by US mail. The notice is deemed to be delivered upon mailing, and a rebuttable presumption that the association mailed a notice in accordance with this statute is established if the board member, officer, or agent or licensed manager provides a sworn affidavit to the mailing. So essentially, this notice of assessment creates an additional 30-day requirement in the foreclosure process, which we'll talk about soon. Assessments that are not paid when due bear interest at the rate provided in the declaration of the bylaws. If no rates provided, then 18% per year. The association can charge an administrative late fee not to exceed $25 or 5% of the delinquent installment if permitted by the declaration or bylaws. Do not charge interest or interest. Do not charge interest on interest or on late fees, just on the assessment. The association is also entitled to collect attorney's fees and costs incurred in the collection of any delinquent assessment. Any payment received by the association must first be applied to any interest accrued by the association, then to any administrative late fee, then to any attorney's fees, then to the delinquent assessment. The application of assessment payments received by the association is applicable regardless of whatever they might put on that payment. It's not subject to accord and satisfaction. You wouldn't be subject to if they pay less than what's full and they put payment in full, that a restrictive endorsement is not going to apply. The association has a lien for all unpaid assessments and can file a claim of lien in the county where the lot is located. You have to provide a 45-day notice of your intent to file a claim of lien. Then after that 45 days lapses without any payment, then without full payment, then you can record the claim of lien. Then you have to issue another notice 45 days of the association's intent to foreclose. So you have that 30-day notice of the late assessment, 45-day notice of intent to record a claim of lien, and then the 45-day notice of intent to foreclose. If you've ever heard the term safe harbor or a first mortgagee safe harbor assessment liability protections, it's referring to the protections that are given to a first mortgagee or a successor in SME who obtains title to a lot by foreclosure or by deed in lieu of foreclosure, and their responsibility to pay assessments to the association it's limited to either 12 months back assessments or 1% of the original mortgage debt. This protection only applies if the first mortgagee initially joined the association as a defendant in the first mortgagee's foreclosure action. This slide is essentially saying that if there's a foreclosure on a sub-association's lien, there's basically no protection for the master association in that context. Third party bidder at a foreclosure property has joint and several liability for past assessment due. However, if it's the association foreclosed, if the association is the quote unquote prior owner, the third-party bidder is not going to be liable for assessments accrued during the time the association owned the property. What's important to know here is that there are ways your attorney can accelerate a foreclosure and assessment foreclosure. These are things that your attorney should absolutely know. Rent demands, the association can make demand upon a tenant for the payment of rent to be remitted to the association if there's a delinquency on the owner's account. There is specific language provided by statute, and there are caveats provided if the association's maintenance, or if the rent is prepaid by the tenant. If there is an abandoned home, the association can appoint a receiver to take over the home. And if the association takes title to that home, the association would of course have to pay the receiver before it gets any monies. Maintenance of insurance, the association is responsible for obtaining and maintaining adequate insurance to cover the common area, facilities, association property that the association is responsible for maintaining, repairing, replacing. The association is responsible for reconstructing and replacing damaged property after a casualty loss. The association should maintain D&O insurance coverage. The association is required to maintain fidelity coverage, meaning fidelity insurance or bonding, for all persons who control or disperse funds of the association. The bond has to cover the maximum funds that will be in the custody of the association or its management agent at any time, but this requirement can be waived by a vote of a majority of the voting interest present at a meeting of the members. This slide is essentially saying, read what your coverages are, make sure they're specific as to what the coverages are. General designation of everything pursuant to statute is not going to provide you with any real coverage. There's certain statute of limitations or statute of repose that may apply to claims for insurance. I was rushing through that because I know that my time is coming up and I really wanted to get to the Fair Housing Act provisions because I think that this is something that is impacting a lot of associations. You'll hear about the ADA and the Americans with Disabilities Act and the Fair Housing Act. They are similar, but again, also very different. The ADA prohibits discrimination based on disability, just like the Fair Housing Act does, but the Fair Housing Act also prohibits discrimination on the basis of race, color, religion, sex, familial status, national origin, and there may actually be additional protected classes pursuant to county law. Like in Palm Beach County, we have sexual orientation. That's one of the additional protected classes under the county's Fair Housing Act. ADA applies to employment, government, public accommodations, commercial facilities, whereas Fair Housing Act applies to private housing, housing that receives federal financial assistance, and housing providers, which would encompass our residential associations. Animals under the ADA, those are only service dogs and maybe a miniature horse, which require particular training. Under the Fair Housing Act, we have assistance animals, which include service dogs under the ADA and support animals, which are your therapy or emotional support animal. Both the ADA and the Fair Housing Act have the same definition for disabled or handicapped, and both may apply depending upon the circumstances. Let's say, for instance, your association has a clubhouse that is offered to the public or rented to the public for weddings, whatever. That particular area may be subject to both the Fair Housing Act and to the ADA. Under the Fair Housing Act, it is unlawful for a housing provider to ask about the nature or severity of a person's disability, or if an applicant who intends to own or reside within the community has a disability, or if a person associated with the applicant has a disability. An assistance animal is not a pet. It's an animal that works, performs tasks, assists, and or provides therapeutic emotional support for individuals with disabilities while a dog is the most common type of assistance animal. Other animals can also be assistance animals, but this is only really referring to support animals. Assistance animals perform many disability-related functions, guiding individuals who are blind or have low vision, providing protection or rescue assistance, providing emotional support to persons with disabilities, with mental disorders. What type of assistance animal is it? As a result of some guidance issued in January 2020 by HUD, which has the overall oversight over the Fair Housing Act, the Federal Fair Housing Act, they really changed the game and how we look at assistance animal requests. Now we have to determine, well, what type of animal are we talking about? Are we talking about a service animal, or service dog, ADA type animal, or are we talking about a support animal? Under the ADA, a service animal is narrowly defined as any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or other mental disability. Performing work or tasks means that the dog is trained to take a specific action when needed to assist the person with a disability. Other types of animals are not considered service animals for the purposes of this definition, and the work or tasks performed by a service animal have to be directly related to the individual's disability, and emotional support, comfort, well-being, companionship, these are not work or tasks for the purposes of a service animal. So how do we determine if an animal is a service animal? Well, first we have to see, is the animal a dog? If yes, okay, then maybe it's a service animal. If not, it's not a service animal, but it might be a support animal. Is it readily apparent that the dog is trained to do work or perform tasks for the benefit of an individual with a disability? If the answer to that question is yes, well, then that animal is a service animal, and you can't ask any additional information. If no, then is the animal required because of a disability? If yes, then you can ask for what work or task the animal is trained to do. If not, well, then the animal's not a service animal, but could be a support animal. If an animal's not a service animal, like I just said, it could be a support animal. A support animal is trained or untrained animal that does work, performs tasks, provides assistance, and or provides therapeutic emotional support for disabled persons. Support animals are not required to be dogs, can be any other type of pet, or can be a unique animal, but there has to be justifications for having a unique animal. What can we ask? Well, it depends on what we know. If we know that the person is disabled and has a disability related need for the animal, or that is the disability or the disability related need is apparent, readily apparent, we can't ask anything. But if it's not, we can ask for information that establishes that the applicant has a disability, and the most common definition of that is a physical or mental impairment that substantially limits one or more major life activities. And we can also ask for information that establishes that there's a disability related need for the animal, meaning that the animal performs tasks or services for the benefit of the disabled person or provides emotional support that alleviates one or more of the identified symptoms or effects of a person's disability. This is a general information about what is prohibited by the Fair Housing Act. This focuses on reasonable accommodations, but there are such things as reasonable modifications, which we don't discuss here. And we really should do another fair housing class, Jeff, if the moment strikes.
Absolutely. There's so much information, folks. We have a course just on this, and it's fascinating.
Yeah, and we haven't done it in a long time, so maybe we should. Florida statute does have a particular section regarding emotional support animals. There is some information about out-of-state providers, telehealth, multiple animals that is covered by this Florida statute and can be used, but you have to just be sure that there is federal law in play here, and sometimes federal law is going to trump your state law. So we are always very careful when we use things like that. This is talking about the keeping of more than one animal and requesting information regarding the specific need for each animal. requiring that the animal be licensed and vaccinated in accordance with applicable ordinance. This particular slide provides you with a little bit of a description of what could be considered a mental or physical or mental impairment, essentially anything. This slide provides for what could be considered a major life activity. Again, essentially anything. You know, right now, the law heavily favors the individual over the housing provider. So I'm not sure that I don't see that changing anytime soon. Recall, the important thing to know here is that recall can be done at a membership meeting or by written agreement. There is a 5 business day window for the board to either certify the recall attempt or not certify it. There is I'm sorry, I'm trying to summarize all this because I know I'm past time, but there is a process by which the board can file for a petition of arbitration with the division. Again, the division has recall jurisdiction here regarding the recall effort or contesting the recall effort.
Don't stress it out. Don't stress it out, Danielle. You have only a couple of slides left. And for those who do need to leave, she is going to go over those last couple of slides, but we did place the evaluation link in the chat if you have to run. Okay, you'll still get your certificate. You'll still get your credit. But go on. Yeah. So, you know, I'm not going to labor on recall too much because you guys are attending this class. You're excellent board members. You're not going to be recalled. This last section has to do with turnover. This is really only applicable if you are under developer control. And you can read that at your own time. Just know that once a developer reaches 50% sales, one member gets elected by the non-developer owners. Once they hit 90% sales, there are lots of things that can trigger a full turnover, but typically is 90% sales. Once they hit 90% sales, they have 3 months to hold the turnover election, where at least a majority of the members of the board become elected by the membership. And there are certain obligations of the developer to turn over books, convey the common property, turn over all records of the association to the owner controlled board. And that's basically it. I'm sorry if it was so fast. I understand. Let me stop sharing. There is a lot of information. Well. God, we typically go way over with these board cert classes. So kudos, great job. Well, I do speak quickly. I try to provide a summary. A lot of information. You have the information there for you. You have my email. Feel free to reach out. And yeah, if you cannot sleep at night, pull out the PowerPoint. Read it. Great reading material. It actually is. It's great reference. And the reason Danielle mentioned it earlier, that take this often, even if you are a continuous board member, is that with the legislation changing stuff all the time, every year, sometimes with special sessions like we had this year, our team of attorneys updates these slides on a regular basis. So you're always going to be receiving the latest and greatest, even if you're in the middle of a calendar year. And even if you've been on the board for several years, it's always good to stay in the know of what is happening, how it affects your association, and how it may affect your pocketbooks. And, Danielle, what else we have coming up? And in just a second, I'm going to go over the evaluation. You're going to say, ask what am I going to say? Yes. You want to ask the attorneys. Two of the firm's originals, Robert Kaye and Michael Bender, November the 8th. Next, I believe that's a Wednesday. No, next Tuesday evening. Election day. Election day. Make sure you vote. Next Tuesday evening, right here on Zoom. You can ask them whatever you want. You're going to dictate the course of discussion for the evening. The link will be on the follow-up email tomorrow, but you could also go to kbrlegal.com and the calendar and RSVP for it right now if you want. But what's cool about it is Now, again, the questions can't be too specific. They don't know your documents. So it's got to be general in nature. It's not considered legal advice, of course, just like today isn't considered legal advice. But you could ask your association related questions, anything, even on the new laws that came out, the past couple of sessions. So Danielle, before I explain the evaluation and how to print the certificates, do you have anything else you'd like to say about how anybody could reach you?
You can reach me here. Again, I'm at the Palm Beach Gardens office. The information is on the PowerPoint if you need it. dbrennan@kbrlegal.com is my email address. And you can check out our website, kbrlegal.com. We have on there all kinds of information like Rembaum's Association Roundup that Jeff Rembaum here puts out every couple of weeks. You can sign up for that. That has great resources, articles, keep you updated on the latest in community association news and all of our courses. Then we also have the KBR calendar available on there where you can see everything that KBR is doing as far as providing everyone with information like our Ask the Experts, Ask the Attorneys that's coming up.
We have Ask the Experts too. We do that as well.
And all of the trade shows that we do and classes just like this. What else is there? You can meet you can see all of our lovely attorneys' faces on that.
Yeah, we also have a relatively new, about a little over a year now, video archive, so you can see a lot. And this session too, while you can't get credit watching this on demand, there's something you missed, you want to catch up and see something Danielle mentioned that maybe flew by you a little bit quickly because your telephone rang or something. This video will be on kbrlegal.com under the resources section within a couple of days. So you'll be able to check it out there as well. So thank you so much, Danielle. I'm going to let you get back to your busy day. I know you're swamped. So thank you for that. I'll be in touch with you soon about doing the assistant animal class. We'll do that for December and early December, so we don't interfere with holidays.